All right, good morning, folks. We're nearing the top of the hour here for our session at 10 o'clock. I know some folks will be dialing in here via Zoom, but we're going to get started in just a moment. Do want to let you all know that have dialed in here before we begin, just a rough agenda. We'll be going through some introductory slides and some information, and Dana will go ahead and has a presentation prepared. Just a couple things I'll highlight here at the top, and again, before we start in just a moment, we are recording today's session. This recording will be posted on emorycollective.com, the university's central hub for all of our digital programs, articles, and information and more. That'll be posted next week, so if you'd like to revisit the session, watch the recording, or share, that'll be up next week. Additionally, we will share out the slide deck following today's presentation. So while we encourage you to take notes or information, we will share out the slide deck afterwards. Because we do have a packed agenda and a presentation, I will be monitoring the chat for any questions that may arise. We've reserved some time at the end of the presentation today to address some questions and make this as interactive as possible. But since we're here at the top of the hour, I'll begin with the formal introduction. My name is Steve Roach. I work with the Emory Alumni Association's Regional Engagement and Volunteer Management team. I work specifically supporting our Mid-Atlantic networks with a specific focus in Washington, D.C., where I live and work. I'm excited for today's presentation as a joint sponsorship between our Emory DC Legal Network, our Emory Atlanta Network, and our Emory Entrepreneur Network, both in Atlanta and here in DC, for a very valuable session, an important session that Dana brought to us today for Emory Explores Common Issues in Filing Trademark Applications. Just a few housekeeping pieces of information that we always like to go over. We are in a Zoom meeting. Most folks are familiar with this in this day and age, but just a few housekeeping notes. Make sure that you keep your microphone on mute. We will have a question and answer session at the end, but out of courtesy for the presentation, please make sure that you are on mute, which you can use at the bottom of the screen. At the same time, we do hope that if you're able, that we can match a name with a face and that you can use the video feature as well. Please make sure you start your video during today's session. That way we can match a name with a face. I'll be monitoring the chat, so if you do have questions for Dana, please drop them in there. We have reserved a portion at the end for Q&A and dialogue, but please drop any questions in there specific to the presentation and topic, but as well if there's any technical issues or challenges, so I can help address that. But we're excited to have Dana here today to talk to us a little bit about filing trademark applications, some pitfalls, some challenges, some successes she's seen, and to provide some industry insight and expertise for our community today. So Dana, without further ado, I'm going to stop sharing my screen and turn it over to you for today's presentation.
Thank you. Thank you for the introduction, and thank you for having me here. I am currently working in my own law firm. I file trademark applications now, but I used to work at the U.S. Patent and Trademark Office on the trademark side and reviewed trademark applications all day long, every day. And unfortunately had to refuse a lot of those applications, which was not something I ever enjoyed. I do not like raining on anyone's parade. But there are just a lot of things that can go wrong along the way. And sometimes that surprises people. They think, it's filing an application through a government agency. It's probably going to be kind of like going to the DMV. If I bring my paperwork and my common sense, I'll be okay. Well, the trademark application review process actually is pretty stringent. So just to give you an idea of what normal is and kind of set your expectations, I pulled these statistics off of the USPTO website. And you can see here T standard and T's plus. These are just two different kinds of application form that you can use to file your application online. But over 83% of these applications filed online have at least one problem with them, sometimes many. But they are not approved on first action. So I just kind of want to set the bar there and make sure you have the right expectations going into the process. Given that there are so many things that can pop up along the way, so many issues that we could talk about, we will not be able to cover all of them today. We are really just going to hit the tip of the iceberg. But I want you to think of this as like a shopping spree and market of trademark law. Okay, we are going to take our little carts, we are going to run through the aisles, and we are going to knock off all the easy stuff that we can in the next hour or so together. And when we finish this up, there will be a lot that we leave behind us in that store, but hopefully you will come out of this with a cart full of useful information. That is my super cheesy analogy, but just go with it. All right, so I want to give you an idea of where we are headed. We are going to start with what a trademark is and what it is not. And that's just so that you get the most out of this that you possibly can. If I am talking about trademarks and you are thinking about patents, it will not be nearly as useful as it could be. So I want to make sure we are all on the same page. And then we will move down here into the big two. These are the two most common refusals issued by the USPTO. So I want to give you a heads up just what those are even about. Hopefully you can avoid them. And then we'll move into the application. And here we'll just talk about some of the places where people tend to get tripped up and some of the mistakes they commonly make there. So hopefully you can avoid those as well. And then hopefully we will have time here at the end for questions. So let's jump right in. What a trademark is and what it is not. A trademark is not a copyright. It is not a patent, but people get these three things confused all the time. That's because they are all lumped together into a category called intellectual property or IP. It's just a category of asset. It's a little bit different than owning a house or a car. But I want you to understand these three things cover very different things. We'll talk more about that in just a minute. They last different amounts of time. Some of them are much easier than others to get. So I'll tell you right off the bat, a copyright registration on average is much, much easier to get than a patent or trademark registration. The review process is much more lenient. The rate of refusal is much lower. Even the filing fees are lower. Another key difference here is that copyright and patent will last for a certain term of years. Then they will expire. So this goes back out into the public domain and people are free to copy. Trademark is actually the only one of these three that does not work that way. So if you get your trademark registration and you keep on using that trademark in the real world marketplace, and you file your maintenance and renewal documents with the USPTO every few years, then you can keep that trademark registration alive indefinitely, forever, or at least as long as there is American law. So that's a really big difference between these. Now, I want to spend a little bit of time, just one slide each, on what exactly each of these things protects. And this is going to be just, high level, broad strokes, but one slide. Trademark is a source identifier. So if you remember nothing else from this presentation, uh, please, please, please remember those two words, source identifier. It's so important. What that means in the real world is that this is a shortcut that all of us as consumers take every day to get more of the things that we already know we like. I'll give you a quick example. One of my guilty pleasures in life is McDonald's French fries. And I know they are horrible for you, but they taste amazing. And if I've had a rough day and I'm driving around and I want some comfort food, I'm going to look for the source identifiers that get me to those fries I know and love as quickly as possible. So that might be the Golden Arches logo. It might be the wording McDonald's. Either way, I see those source identifiers. I know I can turn in there. I'm going to get the fries I want. I do not have to drive around to 4 or 5 different restaurants and order the fries and see if I like them. So when you think about trademarks, you want to think about slogans, logos, product names, names of service providers. There are other things that can function as trademarks, but those are some of the most common ones. All right, now when we talk about copyright, this is something a little bit different. This is protection for original works of authorship. And here we want to think about things like books, paintings, movies, photographs, songs, things of that nature. And I want you to understand that copyright protects the substance of those works. So the composition of the song or the text of the book. But note, this does not tell me where to go to get the songs that I like or to get the books that I like. That would be the realm of a trademark. And then lastly, we have patents. Here we are talking about protection for a new and useful process, machine, manufacture, composition of matter, or improvement to any of those things. And patents can get super technical. We are not going to do that today. I just want you to think about things like inventions, a new type of product, maybe a new feature for an existing product. This product might have been around for 30 years, but you have found a way to make it more efficient or more user friendly. That might be patentable, or a new way of doing something. And again, I just want to emphasize there is a difference between the patent and the trademark, and that the patent is going to protect something like the design of that new product. It is not going to tell me where to go to get that new product. That would be the realm of trademark. Okay, so we have distinguished patents, trademarks, and copyrights. I am now going to take you to the one and only flowchart slide of the presentation. So hang in here with me for just a couple minutes, and I promise it is all downhill from here. All right, so in the beginning, you have a mark, and if that mark is used with goods, we call it a trademark. If it is used with services, we call it a service mark. But for purposes of this presentation, I'm just going to say mark or trademark. People are much more familiar with the word trademark, so it seems to be easier for everyone to understand. We're just going to stick with that. So you have a mark, you want to protect it. You apply to the USPTO to register your mark. The USPTO is the US Patent and Trademark Office, and this is a federal government agency that exists in large part to review these kinds of applications. Now, about 3 or 4 months after you file that application, an attorney at the USPTO is going to pull that. These are assigned at random, so they never know what they're going to get. You never know who you're going to get. And they review that application looking for dozens of possible problems or errors. And they also search the Federal Register for similar marks. So when I talk about the Federal Register, this is just an enormous database that the USPTO has of all of the trademark registrations they have granted in the past. So they are going to look through that database and see, does anybody have a mark that is similar to yours or the same as yours? If they do, then you make it a refusal. It's called a Section 2D likelihood of confusion refusal. It's the most common refusal issued, and we will talk more about it in just a few minutes. But for purposes of this slide, we are going to pretend they don't find any similar marks. There are no other problems with the application, and it goes straight through to approval. Now, you will remember from a few slides up, that is the exception to the rule. But today we all get to be exceptional and we go straight through to approval. So I want you to understand one thing about approval. It is not the same as registration. You are not across the finish line yet. The approval just means the USPTO doesn't have a problem with the application. It then opens this up to the general public and says, okay, does anybody out there have a problem with this application? And so if someone thinks they have a mark that is very similar to yours, they can file what's called an opposition. They have 30 days to do that. Usually that doesn't happen, but it's not uncommon. So for purposes of our slide today, we're going to say no one from the public opposes you and you get through to registration. So once you have that registration, you have several benefits. I'm just going to hit the top 3 in my opinion. The first is that you get to use this circle R symbol. Now, before you have that federal trademark registration, you can use TM or SM next to your mark or your logo. But once you have that registration, you can use the circle R. Now, you might be sitting there thinking, oh, why do I care if I get to use a circle R symbol? This puts people on notice that you have this federal trademark registration. So if someone goes on your website and they see this, they pick up your product packaging and they see this, they know you have that registration. If they were thinking about using a mark that was similar to yours, hopefully this is going to make them think again and back off. It has a deterrent effect is what they call it, but it kind of puts people on notice and makes them rethink using a mark too close to yours. Now, your second big benefit is that your mark is in the federal trademark database. And what that means is whenever somebody else files an application to register a mark, it's going to go through this whole process just like yours did. And when that attorney at the USPTO is reviewing their application, they are going to search through the Federal Register. And if that mark is too close to yours, your mark is going to pop up in that search. And the USPTO attorney will refuse that application from that newcomer and say, I'm sorry, you can't have this registration. Someone else already got to the party before you did. And, too bad, so sad. Okay, and then your third big benefit here is that there is a presumption that you are the owner of that mark. So without getting hyper technical, basically this just means if there ever was a legal dispute in a court about who owns this mark, you get the benefit of the doubt. The evidentiary burden is heavily on that other party who's trying to claim that they own that mark. So you always want to be in that position. You don't want to have that heavy burden on you. So I think that's another big benefit. All right, now we are going to move on to all of these much easier, not flowchart slides. A federal trademark registration means that you have the exclusive right to use your mark in connection with your identified goods or services throughout the US. The part of this that sometimes surprises people is this in connection with your identified goods or services language. Sometimes people call me up and they think if they have a federal trademark registration, that means they can use their mark with anything under the sun and they can prevent other people from using that mark with anything under the sun. Okay, it does not work that way. So when you file your application with the USPTO, you will have to tell them what you use that mark with. Remember, the mark is a source identifier, so it is supposed to be identifying the source of certain goods or certain services, or both. So you have to explain what you use your mark with. I use my mark with legal services. You might use your mark with clothing or fragrances or pretzels or pet food, whatever the case may be. But you have to explain that. And then that determines the contours, the boundaries of the protection that you get with that registration. And hopefully this will make more sense as we go along. But you not only have to explain what you do, you also have to put that into the correct class. Now, what do I mean by that? Well, the USPTO uses a system of 45 classes of goods and services. So everything has a place within this system. My services, legal services, are down here in class 45. So beware, the headings are not always super helpful. I don't really know what personal services has to do with legal services. But class 25, for example, this is hitting the nail on the head. Clothing goods, any of your standard hats, pants, shoes, shirts, that kind of thing, that's going to go in class 25. If you had clothing that was a little bit different, if it was like protective gear that you wear on a construction site to try and avoid having any accidents or injuries, that would actually go in class 9. If your clothing was those gowns that we sit in very awkwardly at the doctor's office, you'd be down here in class 10. If your clothing is not even for humans, if it's doggy jackets or pet clothing, you're over here in class 18. So that's just kind of give you an example of where some of these things go. But there is a proper place for every good or service somewhere in these 45 classes. Now, the reason that that is important is that the total number of classes in which you identify goods or services will determine the amount of the filing fees that you pay to the USPTO just to have your application reviewed. So I'll give you a quick example of how that works. You might have a lot of clothing goods here in class 25. You could easily list off, 50 different kinds of clothing, scarves, hats, pants, shoes, on and on. Well, if all 50 of those are in class 25, then you will pay only one filing fee for one class of goods. But if you had clothing in class 25, and maybe you also had jewelry in class 14, a lot of people sell both of those things. Maybe you also sold sunglasses in class 9, and maybe purses in class 18. And maybe you have a website where you sell all of those things. That's a class 35 service, online retail store services. So now you're talking about 5 classes of goods and services, and you would pay 5 times as much in filing fees as if you were just trying to register your mark with class 25 clothing. Okay, so that's a quick overview. Hopefully this will make more sense as we go along. I want to move now into our second topic, the big 2. Remember, these are the 2 most common refusals issued by the USPTO. And a lot of times people get these refusals and they read through them, and at the end, they're still like, what does this even mean? It may not come as any surprise to you. Attorneys are not always the very best communicators or writers, or trying to be. So my hope today is just to kind of break down what these two refusals are about so that hopefully you can avoid them. And if not, you will at least understand what the issue is when you get that refusal. All right, so the first one, the most common, is the Section 2D likelihood of confusion refusal. And this just means that somebody got to the party before you did. They have registered either your mark or something very close to it. And that is blocking your path to registration. So this is pretty much every business owner's nightmare. And this is why people who are involved in branding or in the trademark world at all are kind of obsessed with searching. Basically, you just want to do sometimes they call it a clearance search or just a search to make sure that no one else out there is using something that's going to create problems for you down the line. So when we're talking about that search, what are we even looking for? Well, we're looking for marks that are confusingly similar. That is no legal phrase that you will see over and over again. What that means in the real world is just, would the average consumer who sees your mark used with your goods or services and the registrant's mark used with their goods or services be likely to think those goods or services came from the same source? And if the answer to that question is yes, then the marks are confusingly similar. Now, a quick note, the registrant is just the person who holds that registration that might be blocking your path. When you file the application, you are the applicant, and the person who already holds a registration, they are the registrant. So we can put this in really concrete terms. If I walk into Target and I see your logo on a bottle of ketchup, and I see the registrant's logo on a bottle of mustard, am I likely to think that mustard and ketchup is being sold by the same company? Okay, which sounds like a super easy question. It can be very, very difficult to untangle, but I will give you an example where we don't have same source confusion. Sometimes it is helpful to see a negative. So we have Delta Airlines, we have Delta Faucets, and these two companies coexist peacefully in the marketplace, even though they are both using the mark Delta. So how does that work? Well, they are doing such different things with that mark. We have airline services over here in this part of the marketplace. We have faucets over here in this part of the marketplace. No one is confused about the source of these goods or services. No one is walking into Home Depot and picking up a Delta Faucets box and thinking, wow, the airlines people have really branched out. No one is confused. So that's why there's not a problem. Now, when we're trying to figure out if there is a likelihood of confusion, we have two main concerns. And I'm going to take a tiny detour here because I know we have some law school students who are part of the webinar today. You may have read this very famous trademark case in Ray DuPont, and you may be thinking, there are a lot more DuPont factors than two. Like, where did all of those go? Okay, that is more relevant in a different context. Like if one company was suing another company over who was the rightful owner of a trademark. I'm just going to focus today on the context of filing an application with the USPTO and what that attorney behind that desk at the USPTO is thinking about. So they are focused on two main concerns. The first is how similar are the marks, and the second is how closely related are the goods or services. Now notice I said similar. I did not say identical. The marks do not have to be identical for this to be a problem for you. If they are, yeah, that can be a big problem, but you also want to look out for marks that look very similar. So maybe they are spelled with just one or two letters off. Marks that have bigger differences in terms of appearance, but that sound the same. That is a very common problem. Or even marks that have bigger differences in terms of sound and appearance, but that put the same overall idea or image into your head. So the classic case for this is Blue Chapel versus Blue Nun. And the USPTO said, we realize chapel and nun don't sound or look the same, but it's basically like blue plus something religious. We think that's close enough. People are going to be confused. So just be aware the marks don't have to be identical. They just have to be similar. And then the same thing going down here. Closely related, I did not say identical. The goods or services do not have to be identical for this to be a problem. If they are, that can for sure be an issue, but there are three main ways that goods or services can be closely related. And the first of these is if we know that a company often offers both of those goods or both of those services. So we'll go a couple slides up. And remember, I said, a lot of times people who sell clothing goods also sell jewelry. So if you filed an application to register your mark with clothing goods and someone else already had that mark registered for jewelry, you might get a refusal there. I have, in fact, written up that refusal many times myself. And I want you to notice here, these are in different classes. So sometimes people think, well, if I'm filing in class 25, as long as no one else in class 25 has my mark, I'm fine. Okay, that is a myth. That is not how that works. You need to look out for whatever else is in class 25, but you also need to look out for those marks that are used with goods or services related to yours, and they might be in a totally different class. Okay, a second way that goods or services can be closely related is if we know that we can often get these things in the same place. So think about when you go to get a haircut. A lot of times when you are checking out at the register, there is this big rack of shampoo and conditioner, and they're hoping you're going to pick some of that up on your way out. Now, if you filed an application to register your mark with hair salon services, and someone else already had a registration for that mark with shampoo and conditioner, you might get a refusal there because we just know it's very common. We can get both of these things in the same place. And then a third main way that goods or services can be closely related is if we often use these things together. So the classic example here is peanut butter and jelly. If you filed your application to register your mark with peanut butter and someone else already had that mark registered for jelly, you might get a refusal there because we just think it's going to be very confusing for people to see the same mark on peanut butter and jelly, but it actually be two different companies. All right, so we know that the search is important. We have a better idea now of what we're looking for in that search, what might be a problem. So how do you do the search? Well, the USPTO has a tool on its website. It's called TESS. Unfortunately, this is not a super helpful tool for most people. So I want to give you a heads up about that. That TESS is a tool of limited utility, and then also just to explain why, what's going on there. So in my former job, this would happen very often. I would issue a refusal. I would get a phone call from the applicant saying, well, I don't understand why I'm getting this refusal because I went on the USPTO website, I searched on TESS, and it said there were no hits. So why am I getting this refusal now? And they felt very frustrated, and I get that. The USPTO knows that this very often happens. They have a warning right here on the website after searching the USPTO database, even if you think the results are okay, do not assume that your mark can be registered. Okay, so what's going on here? Well, TESS is very robotic. TESS does exactly what you tell it to do, nothing more, nothing less. TESS is not Google. You type something a little bit off in Google and it says like, oh, did you mean? Okay, TESS is not going to ask what you meant. TESS is not that sympathetic. TESS is just going to search whatever you put in there. So as a quick example, if you search Disney with two E's and hit submit query, you're going to get no TESS records were found. And if you search Disney with two I's and hit submit query, again, you will get no TESS records were found. Now, does anybody think that you could file an application for Disney with two E's or Disney with two I's or, I don't know, animated phones and get that through to registration? No, there is no way on earth, right? And you know that, and I know that, but TESS does not know that. So if you wanted to do a search that was going to bring in some of those marks that we know can be a problem, marks that are spelled slightly differently, or marks with bigger differences in appearance but that sound the same, you would need to search something more like this, okay? And then you would end up getting 771 active records, including a lot of Disney with the correct spelling, some things like this, which are not exactly Disney, but it's kind of in the ballpark. You would want to see all of these things when you're trying to figure out if you can actually get your application through to registration. Now, if you look at that and you think like, what even is that? Okay, I fully sympathize and I will be totally honest with you. The only reason that I know how to do this search to get to what I want to see is because when you work in the trademark office, they spend weeks like training you how to do this. You end up doing these searches many times every day. You get better at it with time. The takeaway for you is that unless you have time to teach yourself how to do this kind of search code, um, Tess is just going to not be super helpful. Tess may tell you there were no records found when you actually needed to see about 771 records. So I don't know of any plans to revamp the test tool or make it more user friendly. That's just kind of the state of the union right now. The other thing I want to mention before we move on from searching is that when you are looking at bargain vendor websites, by which I mean these companies that say like, we'll file your application for $199 or below 200s or something like that. Make sure that you know what you are getting for that. I do not know of any of them that do searches like this. So I want you to look in particular for wording like this: direct hit, direct conflict, similar wording like that. It usually means the search is only going to pick up marks that are identical to yours. Now, you already know how to do that. I've just shown you. You can go on Test and search your mark yourself. You will have your results in less than a minute. You also know that's a really incomplete search that may not be showing you everything you need to see. So, why you would want to pay someone hundreds of dollars to do that search for you, I don't know. It's your money, do with it what you want, but know what you're getting. Don't be taken advantage of. All right, we're going to move on now to the second most common refusal issued by the USPTO, and that is the Section 2E1 mere descriptiveness refusal. It is all in the name here. The problem with this kind of mark is that it is merely descriptive of the goods or services. And remember, the mark is supposed to be telling me where to go to get the goods or services that I want. But here it's just telling me about the goods or services, and that is a problem. Now, it is a little bit more complicated than that, but remember, we are just knocking the easy stuff off the shelf today. Over 80% of the time, this is what's going on with a mere descriptiveness refusal. So I'll give you a quick example. If our mark is delicious cupcakes and our goods are cupcakes, well, what in this mark is telling me where to go to get these goods? Nothing, nothing. Cupcakes is just telling me exactly what I'm going to get. And delicious is a feature of those cupcakes. They taste good. Well, I know I want cupcakes that taste good, but where do I go to get those cupcakes? If it was like Dana's cupcakes, okay, that helps me to distinguish these cupcakes from other cupcakes. But delicious cupcakes is not doing that. It is not doing the heavy lifting of a trademark. Now, the flip side of this, the other way to see the problem, is an issue of fairness. If I sell cupcakes and you sell cupcakes, we both need access to this word, even just to tell other people what we are offering. And delicious, this is just a bragging word. And we kind of feel like everybody needs to be able to brag about how good whatever it is that they are offering is. And so, if we give somebody exclusive use of cupcakes and somebody exclusive use of delicious, then you have to think about, well, what's left for the next person, even just to describe what they are doing, like not bad baked goods with frosting on top. And at some point, it becomes ridiculous. So we feel like this is the kind of wording that everyone who is selling cupcakes needs access to, should be able to use just to tell people what they're doing. All right, now I want to emphasize for you that the problem in a mere descriptiveness refusal situation is the relationship between the mark and the goods or services. It is always a relationship issue. So let's change up the goods here. If instead of cupcakes, we had shampoo, well, guess what? We are no longer in mere descriptiveness territory because now cupcakes is no longer telling me exactly what I'm getting. Cupcakes is a totally arbitrary word used with shampoo. And delicious, well, I hope that none of us are eating our shampoo. This is just not a word we typically use with those kinds of goods. So with totally different goods, we are now outside of that refusal. It is always, always, always about the relationship between the mark and the goods or services. I want to show you one more thing before we move on to our next topic. And that is something that applicants sometimes try to do to get around this refusal. It does not work. So I want to give you a heads up about that. So sometimes people will come up with a really creative spelling, all right? And I love the creativity, E plus for effort, but this is not going to get you out of that refusal. The problem is when I read this out loud, it is delicious cupcakes. I know exactly what you are talking about. And so that creative spelling is just never going to get you around. Last one before we open things up for questions. And we are just going to dive into the application. We will not have time to go through line by line everything you'll be asked for, but I just want to focus on the places where people tend to get a little bit confused about, well, what is it I'm even supposed to be doing here? Okay. So this is just the first of several pages in that application form. I do not expect you to read it all right now. This is just to get you familiar with what to expect. Um, you are filing for a standard character or special form mark. Now, a standard character mark is when you are protecting wording, just wording. If you have any design element that you are claiming as a feature of that mark, you will be down here in the special form bucket, and we will come right back to special form marks. Let's focus first on standard character. This is the broadest possible protection that you can get for a mark that consists of wording. The reason is standard character marks are for any stylization, any font, any color of that wording. So this is great in terms of planning for the long term. Hopefully you like the way that your mark looks today, but 5, 10, 15 years from now, you might feel like, it doesn't feel too contemporary at this point. We need an update. So you can change your font. You can change the arrangement of that wording as long as it still reads the same. And a standard mark, this is where we have any kind of design element. It could be just a design element, like you think about the famous Nike swoosh. It could be design elements plus wording all in one mark. Um, Either way, you will have to upload a mark drawing. And that is just the design itself. So if you hired a graphic designer to come up with this for you, it is that JPEG file that they sent you. It is not that image on your website, on your t-shirt, on your product packaging. That would be used for a specimen. We will talk more about specimens later. That's showing how your mark is actually used in the real world marketplace. You do not want to upload a specimen for your mark drawing. That will create a nightmare for you. You also do not want to upload a mark drawing for your specimen. That is a quick way to get yourself a refusal, and you can avoid it. So just remember, for your mark drawing, you upload the design itself. If you upload that design in color, realize you are claiming those colors as a feature of the mark. So you are limited to that particular color scheme. If you want a little bit broader protection, you want to be able to use your design in any color scheme that you like, then you upload your mark drawing in black and white, and you do not claim color as a feature of the mark. If you claim black and white, you are stuck using that design in black and white, which is usually not what applicants want to do. So broadest possible special form mark protection, a black and white drawing, no colors claimed. Now, I will mention just really quickly before we move on to the next slide where I show you how this works, that when you see in the application here, you have standard characters, you have special form. Over here, it also mentions a sound mark. So there are multiple different things that can function as marks. A sound mark, would be like when you turn on Roku and it goes da-da-da-da, da-da-da-da. Okay, well, that makes you think of Roku. So it is a source identifier. As long as the sound functions in that way, it could be used as a mark. Well, We are just going to focus today on standard character and special form because these are by and large the most common marks used. All right, so the way that this works, and I'm just using my own mark, I don't get into any trouble for doing that, is if you have a standard character mark, you can just put DDL, Dana Dixon Law, and guess what? You can use this in any font. You're not stuck with this one. You can use it in any color that you want. You can move things around. You can stack the wording. I can put DDL on top and Dana on top of Dixon Law. You know, I can move it around however I want. It really gives me maximum flexibility. Now, if I have a special form mark and I want the broadest protection I can get there, no colors claimed. I'm going to upload my black and white drawing. And now I am claiming this little rectangle. I am claiming these letters in this particular arrangement, in this particular font. I'm claiming the arrangement of this wording over here to the left of the rectangle. So I am stuck with that particular arrangement of design elements, but I can use them in any colors that I want. And then lastly, down here, we have our special form mark where colors are claimed. We're going to upload the drawing with the colors. And here I am stuck not only with all of these design elements in this particular arrangement, but I am also stuck using these colors from now on. That is all the registration covers. Okay, so let's move on from standard character and special form. Let's talk now about 1A and 1B. These are filing bases. And listen, I fully realize the people who came up with these names did nothing at all to make them interesting or memorable. But 1A just means I am already using my mark in the real world marketplace. So if you go on my website, you buy my product, you're going to see my logo on my website. You're going to see my logo on that product packaging. 1B means I'm not there yet, but I intend to use this mark in the marketplace soon. Now, how soon is soon? We can talk about that in Q&A if you want. But the takeaway here is just that you don't actually have to be using your mark in the real world marketplace when you go to file your application. Now, I do want you to understand that if you file 1A or 1B, either way, you will eventually have to prove to the USPTO that you are using your mark in the real world marketplace. Consumers are encountering this before you can get through to registration. And you do that by submitting the specimen of use, which I mentioned earlier. That is just, a screenshot of your website with the logo on it, or a photo of your product packaging with the logo on it, that kind of thing. Many things can function as specimens. Those are just two possible examples. So when you file 1A, I'm already using it, then you put that specimen in the application itself. If you file 1B, you are buying yourself a few more months to be able to show that you are using that mark. And when I say buying yourself a few more months, I mean that quite literally. So you filed 1A, already using 1B, not quite yet. Either way, your filing fee is going to be the same. But when you file 1B, when you're ready to show that specimen, ready to prove that you are using that mark in the real world marketplace, you will have to pay another fee, which is $100 per class. So if you have one of those 5-class applications, that's going to be $500 just to file that specimen. Now, you may be wondering, well, why would anybody ever file 1B then? Why wouldn't they just wait until they had actual use and file 1A? So the thing is, our Federal Register is first come, first served. So a lot of times people are afraid. I have this wonderful idea. I'm sitting on it. What if someone else comes up with the same wonderful idea and they file their application first? So you know what? It's worth it to me to pay a few $100s extra just to secure my place in line. And that still ends up being cheaper for me than having some protracted legal battle with someone over this mark. So that is typically the thought process when people decide to go 1B. The other thing I want you to notice here is that I said and or. So it doesn't have to be one or the other. You can do this by class. So you could file your class 25 goods as 1A. You could file your class 14 goods as 1B. You can also do it within the same class. So let's say you are a clothing manufacturer, and right now all you are doing is sweaters. Okay, so you're 1A as to sweaters, but you plan to expand into footwear in the future. So you're 1B as to footwear. That's not a problem. You can do that in your application. You just have to pull those goods apart and specify which one is 1A, which one is 1B. There are pros and cons to doing that, but it is an option that you have. Now, one more quick thing before we move away from this slide. This is what the application section will look like. You'll see 1A, 1B. Well, notice over here we have 44D and 44E, and I've crossed through them. And why didn't I talk about them? Well, these are filing bases that you would use if you had already filed an application to register your trademark in a different jurisdiction, somewhere outside of the US. So if you had already filed an application to register your mark on the Italian trademark registry or something like that, then you might be interested in filing 44D or 44E. I think for most people in this webinar today, that is not going to be super relevant. So that is why we're focusing only on 1A and B. Now, our last topic, and then we'll open things up for questions, is specimens. So remember, they screw up and then they get refusals and it could so easily be avoided. All right, if your specimen is you have to include this information. That is new as of this year. Where maybe you're not actually using that mark in the real world marketplace. And marketplace. I mean,
Hi, folks. Dana seems to be having a bit of audio issues. Dana, if you can hear us, your audio dropped out and your screen is frozen there. And I believe she's going to log back in here in a second. We apologize for those technical difficulties. So Dana will log back in here in a second. So we'll give her just a moment. I mentioned at the top, I see many people taking notes, and that's fantastic. We are going to have question and answer with Dana here in a second. At the same time, we will be sharing out the slide deck and recording of this session. So there's an opportunity to read in more detail. If you've been taking notes from the slide or have specific questions, Dana will be sharing that out afterwards. So while Dana dials back in here, we apologize for the technical difficulties, but we'll have her back on the line in just a moment.